What is the child custody process like in California? When parents separate or divorce in California, one of the first and hardest questions is what will happen with the children. The custody process can feel overwhelming at first, but once you understand how it works, it starts to make sense. Hi, I'm Niku Berenji with Berenji Divorce and Family Law Group, formerly Berenji & Associates. In this video, I'll walk you through what the process actually looks like, step by step. In California, child custody is decided based on one guiding principle: the best interests of the child. Everything, every form, every hearing, every recommendation comes back to that standard. The court isn't looking to punish either parent. Its focus is on what arrangement supports the child's stability, safety, and well-being. Let's start with the basics. There are two kinds of custody in California: legal custody and physical custody. Legal custody refers to who makes major decisions about the child's life, things like education, healthcare, and religious upbringing. Physical custody, on the other hand, is about where the child lives and how much time they spend with each parent. Each of these can be joint, meaning shared, or sole, meaning one parent has primary authority or residence. Most cases today start from the assumption that joint custody in some form is best for the child, unless there's a reason it would be unsafe or impractical. So, how does the process actually begin? It starts when one parent files a request for order asking the court to make custody and visitation orders. If you're filing for divorce or parentage, that request can be made as part of a larger case. Once the paperwork is filed and served, both parents are required to attend child custody mediation through family court services before any judge makes a decision. That mediation step is one of the most important parts of the entire process. A neutral mediator meets with both parents, sometimes together, sometimes separately, to help them reach an agreement about parenting schedules and decision making. In many California counties, if parents reach an agreement in mediation, it becomes a court order. If they can't, the mediator may write a recommendation for the judge depending on local court rules. Even though it can feel intimidating, mediation is often where the real progress happens. It's an opportunity for parents to focus on their children's needs outside of the courtroom, and sometimes it can prevent months of litigation. If no full agreement is reached in mediation, the case moves to a custody hearing. Each parent, usually through their attorneys, presents information to the judge about their proposed parenting plan. That might include school records, work schedules, testimony, or anything else that shows what arrangement serves the child's best interests. In some cases, especially when there are concerns about safety or neglect or a child's specific needs, the court might order a child custody evaluation or appoint minors counsel. That's an attorney who represents the child's voice in the process. The judge then issues temporary or final custody orders, which can always be modified later if the circumstances change. Now, what does the court actually look for? Judges in California consider a range of factors, including the child's age, the health, the emotional ties with the parent, each parent's ability to care for the child, and in some cases, the child's own wishes if they're mature enough to express them. The court also looks carefully at any history of domestic violence or substance abuse, since safety always comes first. It's also important to remember that what I'm describing here is a simplified version of the process. Every family is unique, and custody cases can become far more complex depending on the circumstances. For example, if there are domestic violence allegations, if there are requests for relocation or move-away orders, or children with special needs, the court may need to involve additional professionals, order additional evaluations, or have more hearings to address those specific issues. These cases often require tailored parenting plans and close judicial oversight to make sure the child's needs are fully met. Once orders are made, parents follow a written parenting plan or custody schedule. That plan sets out everything from exchange times to holidays and vacations. It's designed to reduce conflict and to give children predictability, two things that make a tremendous difference during a family transition. And as families grow and circumstances evolve, custody orders can always be revisited. If a parent relocates, if work schedules change, or if the child's needs shift, either parent can file a request to modify custody. That same best interest standard would still apply, and courts usually encourage mediation first before any hearing. A common question we hear is whether you can represent yourself in this process, and yes, you can. Many parents in California do, especially in the early stages, because the courts provide self-help centers and there are standardized forms. But custody is one of the most sensitive and high-stakes areas of family law. Even one small mistake, like unclear wording in an agreement or missing an opportunity to present evidence, can have lasting consequences. Having an attorney, even in a limited capacity, can help you understand the strategy behind each step. It can help you make sure your agreements are enforceable, and it can keep the focus where it belongs, on your child's best interests. So, to summarize, California's custody process is designed to protect children, not to reward or punish parents. It starts with mediation, moves to hearings if needed, and always centers on one question: what arrangement best supports the child's stability, safety, and growth. And while every family's path looks different, understanding the framework helps you navigate it with confidence and purpose. If you'd like to learn more about mediation, parenting plans, or custody evaluations, please explore our other videos. The more informed you are, the better equipped you'll be to make decisions that truly serve your family's future.